Welcome to the Immigration Talk Show brought to you by Sakshi TV. My name is Ranjit. We are with attorney Prashanthi Reddy today to discuss the latest updates on H1B, travel ban, green cards, and other immigration matters. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. Before that, I would like to reiterate the disclaimer. Please note that the show is not intended to provide any legal advice and is general in nature and only for informational purposes. Hi, Prashanthi Reddy garu, how are you?
I'm good, thanks. How are you, Ranjit?
I'm good. Thanks for asking. So yeah, today, we would like to discuss some topics and we can take some calls. Before someone calls in, let's, have a couple of discussions. So I was hearing that, there is a new proposal called HWRA Act, which is being included with the COVID Bill HEALS Act, the Healthcare Workers Resilience Act, which recaptures 40,000 of the unused green cards to doctors and nurses. Do you think this will reduce the backlog and any possibility of dates moving forward for EB2, EB3, and EB1?
So, as you know, Ranjit, a lot of things are happening. So the numbers are moving forward, irrespective of the introduction of this new bill. And they're moving forward, especially, we care mostly about Indian nationals. So with reference to Indian nationals, they're moving forward with EB3 has shown a steady move forward in the last few months. And further again in August, they have said it will move forward. I was reading the updates by Charlie Oppenheim, and he did say that, there will be further movement on EB3. And as you know, always just before October, there is a rush to use the unused visa numbers. So you see a movement, and the dates change because they use the final date or the the processing date. There are two dates in the visa bulletin, and they switch that sometimes. And because of that, you have more numbers becoming available. And that happens every year before October. So we can expect that to happen and therefore dates to move in September. We can expect generally more EB3s available simply because the numbers have not been used up because 485s are not being filed and also because biometrics are not available. So a lot of people are holding on to the 485s. And also, obviously, the big push from immigrant visas, people filing from abroad, from outside the country, that is not there. That's at a standstill. So those numbers haven't been used either. So you can expect some movement in the near future. With reference to the bill, there's so many bills that it's, sometimes, I don't keep track sometimes because until the bill actually comes to a certain point where you take it seriously, things happen and bills keep getting amended and they get dropped and, so let's wait and see what happens. But if it's a good proposal because it'll help with COVID, they're saying, it's a common sense thing to do during COVID time to use the unused visa numbers from previous years from 2019 for doctors and healthcare workers, nurses. So it makes sense. I don't have the statistics on how many cases are pending for, healthcare workers or that particular category. If we knew, we could maybe predict better. But yeah, 40,000 visas is quite a lot. So will that really trickle over and make a difference for EB2? Because most of these doctors are EB2. They all have MD. So an MD is pretty much a professional degree, so that they qualify for EB2. Nurses could be EB3 as well because they have a bachelor's degree. So it could trickle down to both EB2 and EB3. We have to wait and watch and see if it will actually help Indian nationals or not. But we're hopeful, we're waiting. Also EB1s, there was further movement for India as well. Yeah, I'm hoping EB1s will become a current, at least for a short period of time. So let's see, let's wait and watch. So the EB1s are basically all the researchers, extraordinary ability people, And the L1s, the people who are on L1A, they are EB1s. So let's wait and watch.
So another question, I would like to ask you is, there are a lot of unused family-based green cards that has gone and that will be unused because, because of the recent ban of April 22nd, as well as the consulate closure all over the world, and also no flights availability because of COVID. I heard that these family-based green cards will have to be spilled over to employment-based as per the INA. So do you think, how is this going to work, and will this be good for people in backlog, and any expectations of dates moving forward quite significant?
Right. So again, in his update, Charlie didn't mention anything about the spillover from family-based. He only mentioned spillover from different categories, employment-based worldwide to then spill over to China and India. So usually they don't use visa numbers from family-based to employment-based. They don't. There's no cross-reference there. It's mostly within the same category of employment-based that they use it. So I don't know if this time they will do that. I mean, it is well within their ability to do it if they want to, as well as use. They're supposed to. They also use the unused visa numbers. I mean, the interpretation is there in the act for both. So again, we have to wait and watch. So far, there is no indication from DOS that they're going to do that. But we will keep giving you updates on the show, and as and when we get them. Ranjit, I think you're muted. Yeah, there you go. Sorry.
Yeah, I would like to say something to the users as well as all the people who are watching. If you need any private consultation, please reach Prashanti Garu at 212-354-1010 or prashanti@reddyesq.com, reddyesq.com. And I would also like to reiterate the disclaimer. Please note, this show is not intended to provide any legal advice and is very general in nature and only for informational purposes. Sakshi TV News or agents are not responsible in any way for your actions, and use this information at your own risk. Okay, let's go to another burning issue that's going on with the F1 visas. So ICE released a memo recently saying that F1 students cannot do just online courses, and they have rescinded the memo later. But then again, they released a memo saying that people won't be able to get F1 visas who are out of the US if they have only online class offerings. So any inputs on this? How is this going to turn out?
Yeah, this is, so Ranjit, this has been like a seesaw of can do, cannot do, ever since it came out, right? So there was, just to backtrack a little bit, there was a press release where they mentioned that, they intend to publish regulations. So again, backtracking further so that our viewers can understand what is actually happening. As of March, the law as it exists is that students can take only one online course of 3 credits. So that's actually the law as it exists. And then what happened during when COVID hit, and then the emergency was in place, they had said, they amended that and said that you could take all classes online. Whether you're outside the country or inside the country, it will not affect your status. It will not affect your OPT. You can do your OPT online as well, remotely. STEM OPT, CPT, it will not affect any of these things. Then in June, for whatever reason, they decided that COVID is over, or I don't know what happened, what motivated this, but they sent a publication. I mean, they released a press release saying that now that the emergency is over, we will give you still some concessions, in the sense that we will allow you to do more than one online course, but you have to do at least one or more in-person courses. So they reversed their stand, and then what happened is within 2 days, this obviously affects universities to a great extent because they're all dependent on foreign students, and
I think even Harvard and MIT filed a lawsuit, right?
right. So the entire departments could actually close down if that happened. And so Harvard, MIT, Yale, and 17 other state universities filed a lawsuit. And the lawsuit was supposed to go before the judge for a hearing. Their first hearing, it was in Boston that they filed the lawsuit. And just the day before, they withdrew their press release and they said that they have no intention of implementing this new regulation. And so, the problem got solved there because they knew they wouldn't win in a court of law because there was no basis for them. It was against public policy and against health, against what CDC was saying, to force universities to open up, because that's what they would do. Universities cannot afford to lose their foreign students. They would just, so then even Harvard and MIT, who was they were planning to do all online starting fall, they would be forced to, then have in-person classes also. And just today there was a news article about how many cases were spread simply through universities. They're tracking that, and there are thousands of cases and they're tracking per university, like Yale is this many thousand, and
Wow.
so it was just a very dangerous thing to implement, and I guess any court would shoot it down, and therefore they just withdrew the press release. So as of now, we're back to the March instructions, whereby everyone can take courses online, whether you're in the country or outside the country. If you're outside the country, US immigration laws don't apply to you anyway, so we don't have to worry about that.
Yeah.
But if you're in the country, you will not fall out of status. You can take all your courses online, as well as CPT and OPT can be done remotely, so there's no issue there.
But then I heard that, people, new students who are about to come, who has their I-20 in hands, they will not be able to get any visas unless university specifically says they offer the in-person instruction rather than online course. So that way,
Right.
there could be significant reduction in F1 students this year, probably because, no visas, they cannot come anyways. And I don't think any in-person instruction would resume anytime sooner with this COVID in place.
So so they sent out this amended instructions that they're not going to implement it, and then again they sent out a clarification because it was not clear that arriving students who are just starting their semester, starting their course this fall, are in any way different from continuing students. They didn't demarcate that. They didn't make a difference. They didn't differentiate. But later on, they again put out a press release that the COVID-related regulations don't apply to people who are just starting their masters or bachelors in the fall. So they would have to have a hybrid setting whereby universities offer some in person and some online, and only if that the I-20 is certified as such, then they would be able to come into the country, even if they've already been issued visas. Some of them might have already been issued visas, but even if they're issued visas, they still cannot come in if they are taking all online classes. So yeah, they did again mention that, but they can take classes remotely. There's no restriction against them taking classes remotely, at least for this semester, and possibly those students could then come in for the next semester, in person to take classes in person.
Prashanti garu, sorry to interrupt you. We have a caller, Naveen from Detroit. Let's take the caller and what's his question? Hi, Naveen.
Hi.
Yeah,
can you hear me?
Yeah, I can hear you. Prashanti Reddy garu, he's here, and you can ask any question.
Yeah, hi, Prashanti madam. Actually, I have a question regarding two things. One is that I was trying to contact you and trying to get help, but I couldn't get in touch with you. second part is actually that I've been laid off, and I asked some suggestion from you to go for like different change of status and all those. That's why I was trying to reach you. But right now the time limit is end of August for me, and I was trying to understand that the flights are not on. Then what happens if I stay more than 2 months or 60 days, which is a grace period if you are losing the job, right? So how that is impacting and how I can manage that, my immigration for future.
Right. So going forward, if you need to reach me, all you need to do is send me an email. But we don't have. You have to make use of this Sakshi program, because this is a free consultation. And if you reach me, otherwise it wouldn't be. So that's why more important that viewers call using this mechanism, to get free consultation. It's not possible for me to do it always otherwise. So again, anyone needs to reach me, just send me an email. I'm always on my email. So with reference to your question, as to what you should do, then your 60 days grace period is expiring in August.
Yeah.
Is that correct?
Correct.
So, and you don't have any job at hand as yet, correct?
Yes. Yes.
So my suggestion to you is, I mean, flights are available, but you have to book in advance. Air India has opened up its website to book flights, and there is a process, of course, that you have to go through. You have to register with the embassy, and then once you go get a flight, you have to be quarantined in India for 2 weeks. So there is a process, but it's not impossible. It's possible to do it. So you could look into that, leave, and then come back when things are better. Or you can file a change of status here in this country. It's possible you can just file for a change of status to a visitor's visa, and thereby, at least giving you some breathing room, because when you file for a change of status to a B2, it takes time for them to process it. So that is your breathing time. And in the meantime, if you get a job, you can again file a change of status from your B2 to a H1 based on your pending B2. Remember, the B2 will take 6 months or more right now to be processed, and most probably you won't even get it until the time that you've asked for is over. So all you're doing is filing it so that you can remain in status. So in the interim, you have to find a job again, and then then it's possible to file a change in status again.
Yeah. So I was trying to reach to you. The reason was to change the status and apply through you. Obviously, it was not a free consultation. I was looking through the appropriate.
Okay, just send me an email. You can send me an email. I will respond. I respond to all my emails.
Yeah. Okay, sure. Thanks. I was trying to get it on a website, but I will try to send an email now.
Right. Thank you.
Thanks, Naveen. So yeah, going back to the same question Naveen asked, a lot of viewers are interested to know how this B2 thing works, because a lot of people, the B2, is it last resort, or you can just apply B2 and stay here, because there are a lot of flights as well now available in Vande Mataram mission. But then do you think everyone has to just apply B2 and stay here, not to accumulate illegal status, or it only apply when it is, you don't have any option, or is the last resort?
So my suggestion is, if you have no business here, you should leave, right? B2 is, you shouldn't misuse the B2 application, because it might get denied, and it's messy because the processing time is just so long now. As it is, it's 6 months or more. Now with COVID, and because for a B2, biometrics have to be given, there's no biometric offices. ACS offices are not open, application support center offices. So you can't give biometrics. If you don't give biometrics, they will not process your case. So you'll just sit there. So yes, if you're on a visitor's visa, if you're done with your travel, if you're able to get a flight, which, as you said, it is possible now, I suggest, rather than filing extension upon extension, leave and come back, next year. Because anything can happen. For example, if you wait until last minute and file a B2 and you do it yourself, there's so many instances in which people have filed it with the wrong fee, or done some, not marked some columns properly, and the cases have come back and then they fall out of status. And I've seen instances where they have received emails in such a situation where their visa was cancelled. So you don't want to mess around or play with your immigration status. Take it very seriously. And if you're able to leave on a flight, leave. If you're not able to, if you're older and you're concerned about, so your the health and getting infected on the flight, so you have to weigh your options, one versus the other.
Sorry to interrupt you again, Prashanti Garu. There is another caller, Sanjana from Texas. Let's take a question from her. Hi, Sanjana. Welcome, and you may ask a question to Prashanti Reddy Garu.
Yeah. Hi, Prashanti. Good evening.
Hi. Good evening.
I'm Sanjana from Texas. I have a question related to my L1. I'm here from the employer. I'm here in the US working for a client on the L1 visa at the client location. So unfortunately, due to the COVID, my employer, they have been laying off. As I was inter-transfer visa, they did not laid off me, but I'm on bench without the salary. So I also applied for H1, which got picked up in the lottery. So now my question is, if my H1B is getting approved, we got an RFE and the employer B has answered the RFE. So if the H1B is getting approved, is it mandatory? Do I need to travel as it was my first H1B to my home country and get that stamped for the state of change of status?
No, it's not mandatory. You have to remember that a visa is, if you've applied for a change of status, and if the change of status is approved, and you will know that because the H1 approval will come with an I-94 at the bottom. So if the change of status is approved, you do not have to leave the country in order to start working on a H1. You can start working as of October 1st or whenever you get approved, whichever is later. The only reason for getting a visa is next time when you travel, in order to come back into the country, you would need a visa. So in your situation, if you're not traveling now, you don't need a visa.
Instead of India, because I don't see the consulates are completely getting open. So India, now the cases have been increasing due to the COVID. So can I choose Mexico and Canada? Maybe late
yes, you
this
can.
year.
You can. But I would just ask you not to worry about the visas right now. Just work on your change of status. Unless you have some urgency and you need to travel, I suggest not to travel. With the things happening nowadays and the law changing every day, every week we have a bombshell. So you don't want to get stuck outside the country for some reason.
Yeah, that is a concern. Suppose, if in case, I'm sorry to bother you, I have a couple of questions.
Not a problem. Also, I wanted to reiterate that Mexico and Canada, the borders are closed. The southern border and the northern border are both closed. But they're closed only for land traffic. But for flights, they're still open. So if you have to get a visa, you have to fly in. You can't drive and try to get it that way. So just remember that.
Okay.
And also the other thing is to get a visa in Canada. Mexico doesn't have a quarantine, but Canada doesn't want people from the US traveling to Canada. So you might end up in a quarantine situation. So you'll need to research that. It's possible that you can go in on that flight and then come back without leaving the airport, on another flight, if that's possible, if you can get the visa that way. But otherwise, it's an issue. The quarantine situation. In Mexico, I think they don't have any quarantine.
Okay. Actually, I have my family in the Canada. So I thought, can I make up any emergency visit to Canada, either through an air or drive? Because they have been considering the Canada is open for immediate family members to enter, right? So can I enter Canada in that way and go for the stamping while driving back to US? Will that be possible?
No, they have. So you have immediate family members in Canada, meaning who? Your spouse is in Canada?
Yes, my spouse is in Canada. He's also working on work permit in the Canada through his company, his employer.
Right. So, I think it's still safer to take a flight rather than
Okay.
going over the land, because I don't know what those exemptions are, whether immediate family members are exempted for only Canadian citizens or anyone
Yeah,
who has an. So I have
Sanjana.
not looked at that. So,
Yes, Sanjana,
I'm
we would,
not sure.
we would recommend that, you reach out to consulate because they would know better because these are some things that, not particularly related to immigration because Department of State operates in a different way. So it's better you reach out
Oh,
to the consulate and, we
Yeah,
have
just
another caller. So,
yeah.
um, yeah, we have another caller, Vijay Bhaskar from New York. Let's take a question from Vijay. Hi, Vijay. Welcome.
Hey, thank you. Hello, ma'am. How are you?
Hello, good, thanks. How are you?
I'm good, thank you. Ma'am, I have a quick question. I'm in a situation I have to go to India because of emergency, but my visa is valid until October 14th, but my company has already applied for my extension. Actually, USC has received my application today. So, if I come back, do they need to reapply my H-1B visa while my H-1B is approved, or like because my I-94 will change, right? So I was just
Do you have a valid visa
wondering.
until when? When is your visa which is stamped
October
in your
14th,
passport?
2020 of this year.
Oh,
October
so it's
14th,
expiring.
2020
So
of
you
this
have to go to
year.
the consulate. If you leave the country, you'll have to go to the consulate. You cannot come back otherwise. And consulates are all
But
closed.
I have until October 14th, right? I can come back before that, right?
If you get a flight, you're taking a big risk, but again, you know what your emergency is. But you should be able
Mm-hmm.
to, if you don't come back by that time, then you have to be prepared to
Mm-hmm.
wait it out. So you have to have that
Oh,
option.
okay.
You have to be prepared to wait it out until COVID gets, everything gets normalized and the
I
consulates
mean,
open up, because then you'll be stuck outside the country.
mm-hmm. Let's assume I can come back, right? If I am able to
Yeah,
come
you
back,
are allowed to come
uh,
back. The proclamation doesn't apply to you because number one, you were in the US when the proclamation came. And then number two, you had a valid visa. But remember, these things are changing every day. So if they send
yeah,
out,
I understand that.
for example, they again amended the proclamation and they said people who are outside the country but have a valid H1 visa, for example, they were supposed to be exempt.
Mm-hmm.
But what they're saying
Oh,
now, they
okay.
put out another amendment saying that people who are outside the country whose visa has expired after the proclamation still cannot go for an extension, cannot go back, until
Oh,
December 31st. So they've added that. They keep adding and deducting people from the equation. So if they change it, then you'll be
uh,
stuck. If they don't, as of now, that the interpretation, they haven't interpreted it in such a way that you'll be affected as of now, but that could change at any time. So that's another risk you take.
okay. The another question is like, say, for example, I would be allowed, right? But what happens with because my I-94, right? Because I have a new I-94 because my H1 would be approved because it was applied in premium processing if I go, right? And then when I'm coming back, would I able to use the new I-797 and then get a new, like the I-94 with 3 years extension, or it's going to be like my company has to reapply my H1B again?
No, they don't have to.
That
I
was the
mean, I
that.
don't know why you're confused about that. If you have a H1B approval, you also have to have a visa. Your visa is expiring, you
Mm-hmm.
said. The visa stamped in your
Yeah,
passport.
mine is
They're two different
expiring
things.
October 14th. October
Right. So you
14th,
have
right?
to
But
get a
I
new
will come
visa.
back
Without
like if
getting a new,
oh,
what you can do
new visa
is
I
go to the
cannot. Okay.
consulate, show your new H1B approval, which is valid for 3 years, if it is valid for 3 years. Get a visa and come into the
Mm-hmm.
country. That's what you need to do.
Oh, okay.
Okay,
Thank you
Vijay,
very much.
thanks for calling. We have another caller, Ranjit from San Francisco. Let's take the call. Hi, Ranjit. You can ask a question.
Hey, hi. Actually, hi, Prashant. I just want to know on the pending receipt, can we do a transfer?
What
Hello?
kind of receipt is it? It's a H1 receipt?
Yeah, yeah, H1 extension is pending. So can we do a transfer?
Yes,
it's been already
you can.
5 months.
Yeah.
It's been already 5 months. I don't have any response, no RFP, nothing till now. So can I move to a new employer because I'm on the receipt right now?
So there are two ways you can do it. One is the cleaner ways, convert to premium processing, get an approval, and then transfer. Because premium processing is available now. So it's easy to convert to premium processing, and you'll get a response in 2 weeks. The other way,
Yeah, but okay, yeah,
the
go ahead,
messier way is, yes, to file the transfer based on the receipt. And then what will happen is, it may not be a bridging petition because your I-94 is still valid as of the date of filing. Has your I-94 expired?
Has been expired. Yes, it's been expired.
So then it is a bridging petition. They will follow the rules of what a bridging petition is. Basically, in a bridging petition situation, they have to make sure that the previously filed pending application is approvable when filed. Okay? So if they think that it is approvable when filed, your previous H1, they will approve the next H1 as well. If they think that it is not approvable for some reason, then they may deny your request they may approve the H1 but deny your request for a transfer. But in general, yes, it can be done. It is done in many instances. A lot of people do it.
I have one more question added to this because my employer, the current where the pending H1B extension, the employer is not ready to do an premium processing. He says he don't have workforce right now, and because of the COVID, I guess couple of employees and he himself got affected with COVID. So he said he cannot do it for next 15 days. But I have you want me to wait till he does it, or is there any way I can do it by reaching any attorney?
So if your H1B extension has to be filed, then has to be filed by the employer. You cannot file it unilaterally. It's an employment-based petition. And if it has to be filed before the I-94 expires, even if it's a day before, it's fine. But it has to be filed before.
Yeah, the I-94 has been expired, but my employer is not ready to do a premium processing.
Oh, he's not ready to do premium processing. Okay.
Yeah.
So the premium processing fee, can be paid by the employee. It's kind of a gray area. The USCIS fee cannot be paid by the employee. No. But there is a little bit more relaxation in the rules when it comes to premium processing fee. So it's possible that you pay the premium processing fee to your employer and then he pays to USCIS. You cannot pay it directly.
I told him the same thing, but he's not ready to do that. He has some reasons.
So that then that has nothing to do with the payment. Yeah, you cannot force him to do it. It has to be done by the employer.
Yeah, that's what. Is there anything I can go? I have any rights to make it premium processing or no? I know it's an employer thing, but yeah, okay. Okay, and thanks, Prashant.
You're welcome.
Okay, thanks for calling, Ranjit. There is another caller, Chandu Prakash from New Jersey. Let's take the call. Hi, Chandu. You can ask your question.
Hi, good evening, Prashant Reddy garu.
Good evening.
Yeah, my question is that actually, I filed it for my brother F4. Already the F4 is granted because it's my paperwork also is done. It is with actually Mumbai Embassy Consulate, and I don't know when there is probably you may be having idea when they maybe process these approved applications already, paperwork, everything is done just for calling for the interviews only. Do you have any idea?
Yes, unfortunately, your brother will be affected by this travel ban. That's the first proclamation. So it's not going to happen before December 31st. After December 31st, if he does not further extend it by another 60 days, then and if the consulates open up, then it's possible. There's so many things in the mix, right? Elections are in November, so if he doesn't win the elections, then I doubt it will get extended by the other administration. But if he wins, there's a possibility that they may extend the proclamation further.
The already approved application and just waiting for the interview
No,
calls.
that is not right. It is still under the ban. It is still under the proclamation because it is not approved. Unless there is an interview, it cannot be approved. So approved meaning that the interview is done and the immigrant visa has been issued. That is approved.
Oh, okay. That's called approved. Until that time, it was not approved.
It's not approved, yeah.
Okay. Oh, okay. One question, another thing. Already one of the kid was already crossing 16 years in August. Do you think that will take it as a serious for or otherwise that the Child Protection Act can protect for him?
It's not Child Protection Act. I mean, 16 years to 20, there's a long time because he has to be 21, right?
21
so there's
years,
a long time for him.
Not 16 years, 21 years, yeah, actually, he's 21 years now.
If he's already 21, then he's out of luck. He will not be able to immigrate with his parents. If he's under 21 and he's waiting for the process to happen and it is not happening because of this proclamation, there is an exception in the proclamation itself that basically says on a case-by-case basis, you can request the consulate for an emergency appointment so that they can take care of these aging out people. So it's possible that he might come under an exception, but you have to contact the consulate. You have to go to that website and request an emergency visa interview and give them the reason as to why you need it. Right? You have to say that one of the child is aging out.
Yeah. Chandu, thanks for calling. We have a lot of callers online. So there is another caller, Raghu, online. Let's take the call. Hi, Raghu. You can ask your question.
Hey, hi. So, like I'm stuck in India due to this. Like I went for H1B stamping. So what's happening is I got an H1 for 1 year, and I already went for an interview, and I got 221G. The 221G. So it's still in process, and I didn't get response till now. So my H1 is getting expired in October. So shall I apply extension? I don't know. We have travel ban till December, right? So what should I do now? Like, shall I apply extension and wait, or otherwise we should not apply any extension since my H1 is expiring, right? So what is the approach we need to follow? I'm currently in India, stuck in, yeah.
So it's not going to be a H1. It's going to be, it's not going to be a H1 extension because you're not in the country. You can wait and you don't have to file anything now. Whenever the consulates open up or the travel ban is removed, the proclamation is removed, you can apply for a H1 then. It's basically a H1 consular processing, and it's going to be exempt. It's cap exempt, so that's what it is. So you'll get another H1 approval, hopefully for 3 years, and you can take that and then go to the consulate when things are better. So there's no need to do anything now because until December 31st for sure. If you want to apply in advance and keep it, you can definitely do that. But you're not going to be able to use that approval to go for a visa until after December.
Oh, okay. So I should not apply for H1 extension? So what should I apply
It's not an extension because you're not in the country. You cannot be extended. It's H1 consular processing.
Okay, yeah, we have another caller, Prashanti. I think Bahu from Florida. Let's take the call. Hi, Bahu. You can ask your call now. You can ask your question.
Hi, Prashanti madam. I had a question regarding my H1 visa. I think somebody asked a question. I think it's like a extension to that question. Somebody asked regarding H1 extension in the process, and they changed the employer. I did exactly the same thing, ma'am, wherein I had H1, I applied for extension, I-94 got expired, and after some time, I joined another employer on the H1B transfer. But currently, both the extension H1B as well as the transfer H1B, both are in RFE status. And the RFE question for the H1B transfer was, your extension the employee's extension is pending. Previous extension is pending, so we cannot give a response back at this point of time. So my new employer is actually asking me to respond back to the older visa, and I did convert it to premium. The extension was converted to premium. They sent me another RFE asking for a new SOW. So they just want to make sure that, if the employee is still working, and if he has continued working for you, and please send us the new SOW from the client, which I don't have with the previous employer. And the new employer is saying, unless you get your previous RFE responded to, we cannot respond back. So I just wanted to understand, what would be your suggestion in my case?
So I think you should respond to that second RFE, because obviously that first RFE is not going to get approved. It is because they're asking for some document information and you don't have that. So, I mean, you should still respond to it to the best of your ability. And the second H1, basically you have to respond to the best of your ability. And then you have to say, if you're not able to do premium processing on the first one and you don't want to wait, you have to basically the lawyer has to step in and tell USCIS what the law is, that bridging applications are allowed. And it's not necessary to get the response of the first one in order to approve the second one. The only requirement is that, the case has to be approvable when filed. And it's very easy to show that a case is approvable when filed. And you can show that. You can show as of that time, there was a job, there was an SOW, but then you transferred. And therefore, you're transferring the job. Therefore, you're not able to respond to the previous RFE. So that's what you should do. And we've done that in the past. And the cases have been approved. So that's your only option as of now.
Okay.
Okay, I think the call is done. So yeah, Prashanti, going back, we have few questions from on the social media. I would like to ask you. The first one is from what Sanjana said. Her employer had furloughed her without any pay. So in this COVID situation, we hear there are a lot of furloughs happening, apart from the layoffs. So how does this furlough work? Are H1B employees allowed to be furloughed? Is that allowed? Our employer can really do that? How employees are, protected against it, or, what can they do if they are furloughed?
So, so basically, again, to backtrack, in the past, USCIS has said many times, I'm talking about 10 years ago, 15 years ago, that as long as a person is paid while being furloughed or on the bench or whatever it might be. So there are two different things. Furlough is you're laying them off and asking, and putting someone on the bench means that it's a temporary situation. You're putting them, you don't have work for them, but once you have work, you're again going to, hire them back.
I mean to ask, when not being paid on, being on H1B. So let's say employer is not being paid.
So if you're still on a H1 and they have not laid you off, they have, furlough is a newer term, but bench was an older term that was used previously. But so as per, in the past, they would allow it as long as, you are being paid. You have to be paid in all circumstances. And then recently there was a new memorandum where they rescinded the employer-employee relationship right to control kind of language. And in that memorandum, they also said that it's possible to furlough or bench an employee as long as they are being paid. They have to be paid. If you're not paying them, then you need to basically let them go. and you need to withdraw the H1. You need to ask for the H1 to be withdrawn. Otherwise, as an employer, you're in trouble. As an employee, that person also loses his status. Now, there is some limited exceptions to this where you don't have to pay, but it's not a furlough. When you don't have to pay your employee on a H1, if the employee is requesting leave for whatever purposes, it could be health situation, it could be due to COVID, it could be family situation. So if the employee is asking for it, then you do not have to put them on the payroll. But if you're not paying them because of an employer situation, then there is no exception for that. You have to pay.
Is there any limit
them at
on
all
how
times.
many days one can take a leave on H1B for personal reasons or family reasons?
There is no period of time that is given in the regulation. It simply says that it is allowed. Obviously, it cannot be misused, and there has to be a reason, and that reason has to continue for the period that you're not being paid or you're not working. You've taken time off. So it's basically unpaid time that you're taking, unpaid vacation that you're taking. Another limited circumstance is, again, it's a gray area, but for some reason, if you're not able to pay them, say, for a month, but you make that up by giving them a bonus at the end of the year, which is a bonus that is confirmed, not a bonus which may or may not happen. A confirmed bonus, end of the year, you might be able to make that up. And so that the W2 amount reflects, the prevailing wage. It doesn't, so that it doesn't dip below the prevailing wage. Another way is if the person is able to pay them, but only part-time, like on a lower wage, then you will find an amendment. So these are the ways that, you can kind of
it was great,
that situation.
Great that, you gave some tips to employers as well. We have another caller, Parag. We'll take a question from him. Hi, Parag. You can ask your question.
Hey, ma'am. How are you?
Hi.
Hello. Can you hear me?
Yes, we can hear you. Go ahead.
Yeah. So actually, I came into so I did my bachelor's over in India in 2005, and 2005 August I came to the US, right? And since then till 2019 July 27th, I was in the US. Okay. So I've had multiple statuses. I've had multiple H1Bs. I've had EAD. I worked on EAD for almost about 7 years. But suddenly USCIS gave me an RFE and they denied my I-485. Okay, it was pending. I got my EAD, so obviously my I-140 was approved from Intel Corporation. And then they suddenly sent me an email, and I didn't know that big corporations do take away the I-140 petitions. So I was under the assumption that under the AC-21 Act, I was eligible, and I got a couple of RFEs, and I did respond to them. And then all of a sudden, 2019 July, I got a mail saying that your I-485 has been denied. At that time, my priority date was not even current, okay? It was going to be about another 4 months or so for my, it is May 19th, 2009. That is my priority date. And they just denied it. And I've used Murthy, Murthy.com. I've used a couple of lawyers. I spent more than, about $10,000, $12,000 already in terms of legal fees. I don't know what fault of mine is being all of my youth I've spent in the America. I've spent for the economy. I've paid my taxes on time. I'm the highest taxpayer. I was more than, 6 figures all the time since I got my job. So I'm not sure what wrong I did and what wrongful, why did they deny my visa? Is there anything you can shed a light on what steps I can take?
I mean, your question is more rhetoric, and more, I sympathize with, what you've gone through, and there are a lot of other people in your situation as well. The immigration system is not fair. But if you have to ask me a concrete question, I can only answer if I know what is the reason for your 485 getting denied, and then we can see if there is a way. I mean, I don't know if it's past that, or you still are able to file a motion to reopen, or so all this is, I think it's complicated to address in a phone call, but it has to be addressed in more detail. I have to look at your RFE. I have to have more details from you. So I definitely sympathize with what happened. You're saying you approached other attorneys. They must have advised you on what can or cannot be done. So I suggest you give me a call or send me an email, and we can look and see if they've missed something which I can catch, right? And we're able to file a motion to reopen or maybe refile. I don't know what the status is. Most probably you're out of status, right?
Yeah, if you have any questions or if you need any private consultation, please reach Prashanti Garu at 212-354-1010 or prashanti@readyesq.com. So we have another caller, Prashant, online. Let's take a question from you. Hi, Prashant.
Hi.
Yeah, you can ask
Hello.
your question. Prashanti is here.
Yeah. Hi, Prashanti ma'am. Thank you for this information segment. My name is Shashank. Sorry about the confusion earlier. So my question is that I have been on H-1B since 2018, and recently I got laid off in May. And now I found a contracting position with a particular company. At the time when they filed my H-1B transfer, they had filed it in regular processing because I was yet to get a client offer and things like that. Now, today I got a client offer and like everything is good to go, but because the H-1B transfer was filed in regular processing, I am yet to get a receipt notice. I only have a FedEx tracking number. My employer says that it is legally okay to start working on the FedEx tracking number, and just wanted your advice on what should I do. Should I hold off on starting work, or is it safe to join on the FedEx tracking number?
So whenever you file a H-1B transfer as per AC-21 regulations, you can start working as soon as the package is received by USCIS. So your proof of receipt is pretty much your FedEx. So if you see that it's been delivered, you can start working from that day. You don't have to wait because the receipt will take 10 days, 1 week. So you don't have to wait for the actual receipt. As long as, so when you do this, remember that you're always putting yourself in some kind of a jeopardy because if it gets denied, then what is your status then? You'll have to go back to your previous employer, otherwise you fall out of status. So, you always have to, it's a catch-22 situation. So you have to always be careful when you start working based on a receipt number, based on, the receipt of the case.
Okay, so on the FedEx website, when I put in the tracking number, I'm able to see proof of delivery. I see that some person has signed and received the package. So if at all USCIS comes back with some, if at all there is some problem in the future, I'm allowed to show this proof of document, like proof of delivery, and say that this is why I started working. So legally, I'm okay to join, correct? Got it. The other question is that I understand that in the future this particular H-1B transfer may get RFE or it may get denied. So I already have a H-4 petition through my spouse's company that is in motion. So if at all the H-1B transfer gets denied, my H-4 petition was filed within the 60-day period. So that will still keep me in status, correct?
How many petitions can you file at one time? And how many petitions can you use? I mean, you have to make up your mind which one you want. USCIS is not going to entertain multiple petitions, right? So as per the last action rule, you have to remember something that is called a last action rule. As per the last action rule, whatever petition you filed last, that petition will trump over the previous petition. Okay, just remember that, and then you make your choices. So if you don't withdraw one of the petitions on time, you might be, forced to be in a status that you don't want to be in. So remember last action rule, decide which application you want to hold and withdraw the other one before it gets approved. You can't do anything once it gets approved.
Okay, thanks for calling. We have another caller named Charan. from Mexico, I believe. Let's take the call and question from Charan. Hi, Charan.
Hello. Hey, how are you doing?
Yeah, we are good. You can ask your question to Prashanthi Reddy garu.
Hey, Prashanthi. Hope you're doing good. So I'm from Michigan. So a quick question that I have is regarding my parents who came to the US in the month of March. So what happened was they came to the US to attend a marriage, and since that time they are stuck here. So basically they are on a B1, B2 visa, a visitor's visa, and in the month of August the visitor's visa is going to get expired. So my quick question is has the government extended that visitor's visa limit of 6 months to something later on, or is it still in place?
So as per regulation, you can be on a visitor's visa for 1 year, totally. But you need to file an extension every 6 months. That's what the regulation is. So you can file for the extension for beyond 6 months, before the expiry of their I-94. That's what you should do. And then they leave as soon as possible after that.
Yes, and since their visa is getting expired in mid-August, like how long? I believe it can be done only sometime a month back, giving it that the consulate is not fully operational.
The consulate has nothing to do with this. You're filing an extension of the I-94, correct? They're in the US. Yeah, so consulate has no business here. You're filing with USCIS, and which is open. So you need to file before the I-94 expires. If that is August, then you need to file before that. At least a day before and maximum of 6 months before.
Okay, got it.
Okay, we have another caller, Ranjit from Hyderabad. Let's take the call. Hi, Ranjit. You can ask your question.
Hi, Prashanthi Reddy garu. This is Ranjit from Hyderabad. So my question is that I'm stuck in India. I have actually traveled to India before June 24th proclamation, and I hold a valid I-140, and my H1 is expiring in October. So can I'm working for an US client as of now. So can my employer file for my extension? Or else if it is consular processing, so what would be the process for the consular processing? Can I get an approval?
So has your visa expired?
My employer.
Why aren't you coming back based on the visa that you have?
I don't have a valid visa.
Oh.
My visa got expired back here.
So for those who are in the same situation, my one way is to file a lawsuit. Already lawsuits are being filed across the country. Join one of those lawsuits. AILA is filing, American Immigration Lawyers Association. They're looking for plaintiffs. So, this is one way of doing it, and it's not prohibitively expensive because it's like a class action suit. So multiple people can join in, and so it's not expensive. So because you don't bear the burden of the entire lawsuit. So this is something that you guys should think about seriously rather than, just doing nothing and just losing your job and being, just being passive. I think you should be proactive, and this is something that you need to look into. But your question was, can I do anything? That is the only thing you can do. Take legal action. Otherwise, you have to wait until December 31st, or God alone knows how many more months after that. If Trump wins the election and decides to extend it, he can. Also, another positive thing is you might benefit from the lawsuits that have already been filed, and hopefully this proclamation will go away or will be made much more narrower in scope. So we have to wait and see for all those who are affected right now by the proclamation and are outside the country. So it's something to keep in mind. Follow what is happening, and let's wait and watch. We will continue to give you updates here on, as soon as we hear something with reference to both those lawsuits.
I think we are almost at the end of the show. So it was a great session today. Thanks for all the calls and watching the show. It was a great session with interesting topics and questions. Please call in every day every Wednesday and watch the Immigration Talk Show every day at 6 p.m. Eastern Time on Sakshi TV. And thanks Prashanthi Reddy garu for all your inputs and advices for employees and employers on H1B. And I hope this was a useful session. And good evening, everyone. And this is Ranjit signing off. Thanks, Andy.
Thank you.